Yeah.
To the Lordship. Item number 2, Mr. Sahayala will be appearing in this case, and he is out of station, so he has asked me to take time. I have taken consent of the other side, my lord, APJCL.
Item number 2.
2. Can you fix on next Tuesday, my lord?
Mr.
He is out of station.
Oh, okay. The 16 matter.
Yes, my lord. So, one urgency also. Can it be fixed on next week, my lord?
Then the senior counsel is expressing some difficulty.
He is out of station.
MS and Saikyal Learned Counsel for the petitioner submits that Mr. G.N. Sahewala, Learned Senior Counsel, leading in the matter on behalf of the petitioner, is out of station and accordingly seeks accommodation in the matter. Stop. Prayer is not opposed. List this matter on next week.
Next Tuesday.
Tuesday nidibo. Tuesday ki bata ase. 19.
18. 19. Obliged.
My Lordship, I beg to mention item number 17 and 18, Your Lordship. This matter may be kindly adjourned for today only, Your Lordship, for hearing. The earlier engaged counsel has expired, so the brief is just received. I need some time for preparation for the hearing, Your Lordship.
17 and 18?
Yeah.
18 is connected with 17?
Yeah, it's I in that.
No, 18 is not connected. Only 17, correct?
17.
Item 17, huh? Your name?
Jet Khalid.
Mr. Jet Khalid, Learned Counsel for the petitioner submits that the leading, who has expired?
Earlier engaged counsel.
That the earlier engaged counsel, Mr. A. Khalid, has expired in the meantime. Stop. He accordingly seeks some accommodation in the matter to make alternative arrangement. Prayer is not opposed. List this matter
Next week.
after 1 week or date did occur. On 20 so and so.
May please, Your Lordship. Lordship, I want to withdraw item number 10. Because of that, my lord, the petitioner was arrested.
In item number 10. You are Mr.
F.A. Hassan on behalf of P.A. Ahmed.
Mr. F.A. Hassan,
Yes.
On behalf of Mr. P.A. Ahmed, Learned Counsel for the petitioner, submits that the petitioner has been arrested in the meantime. Stop. Accordingly, the anticipatory bail application has become infractious. Stop. Anticipatory bail application stands dismissed on withdrawal.
Yes, obliged.
Disposed of.
May please, Your Lordship. I beg to mention item number 12. I need 2 days accommodation to file affidavit, my lord.
You are for
Government. My lord, my friend is also there.
Mr.
G. Bokolial.
G.
Bokolial.
Bokolial, Learned Counsel for these. You are a
Junior
government advocate?
Government advocate. Junior
Learned
government.
government advocate for the state respondent seeks
1 week time.
1 week time to file the return in the matter. Stop. Prayer is not opposed. List this matter after 1 week on a date to be fixed by the registry.
Deeply.
Listing of what? Ajitu Ase? Mention before the appropriate bench. Call the list, please. This has come earlier rejected by this court? Similar FIR this court has. Where is the similar order?
Yes, Lordship. Page 29, 18.
18.
Yes, you have your updated case.
My lord, I'll furnish, my lord.
When do you, shall I keep it on Friday?
It is, my lord, from South Salmara, my lord.
Lordship, one similar matter, Lordship, was fixed on 21.
21. My lord, on
Interim for interim, Lordship. It was, Lordship, on the each occasion, Lordship.
my lord, it is 326 and 307 section is involved, my lord.
Then have it on Friday.
My lord.
We are posting it on Friday.
My lord.
This Friday. We will try on this Friday.
My lord. On 14, my lord.
At least if a case is made out, the petitioner can enjoy the...
My lord. My lord.
Yes. Okay. Call for CD, list on Friday. Updated CD, huh?
My lord.
May I please your lordships? I'm appearing on behalf of R.B. Bora. She is on legs in court number 1. Kindly pass over.
What about the instructions?
She
All right.
will appear in this matter.
Pass over for the time being. This is that maturity death matter.
My Lord, by the last order, the records of treatment of the petitioner's mother was called for. And that is awaited now. Otherwise, affidavit is filed pursuant to court's order.
None appears for the petitioner when the matter is called. Mr. B. Gogoi, Learned Standing Council, Health Department, submits that the records pertaining to the treatment of the petitioner's mother as called for by this court by order dated 4/6/2024 is still awaited. Stop. List this matter after?
My Lord, after 2 weeks, my Lord.
After 2 weeks on a date to be fixed by the registry.
I am obliged.
None appears for the petitioner when the matter is called. List after 2 weeks on a date to be fixed by the registry. You've received the case diary?
My Lord, search sheet file, my Lord.
All right.
CS number, my Lord, 22/2024.
So, you will appear until then in interim.
My Lord.
Marshway, you have the sample order for this. Then charge sheet number, please. CS.
My Lord, CS number 22, my Lord, stroke 2024, my Lord, dated 3/1/24.
An interim protection till then, granted earlier. 10 days. Within 10 days. Before which court?
Before, my Lord, it is before CJM Kamrup, my Lord.
CJM Kamrup. Disposed of. CD there.
7 also, my Lord, search sheet file, my Lord.
Who is appearing in 7? Mr. ATM Hussain.
Petitioner is absent.
I think we'll keep this for some time. You can, in the meantime, if you can ask one of your associate to contact the petitioner's lawyer. This will be also a similar order. But
in 8, my Lord, we have not received the case diary, my Lord.
await up-to-date case diary. List again on such and such date. Interim order passed earlier shall continue till the next date of listing. Date.
Date, my Lord, Nalbari, my Lord. On, my Lord, 19.
All right. Yes, Mr. Bora. Case diary?
Case diary received.
Yes. What is this, Mr. Bora?
The indication is that the altogether 16 command certificate are issued by the Home Guard. When it reached the office, it became 63.
How many it was?
63.
So the allegation is that where is the FIR?
FIR in page number 9.
Are you on interim?
I am on interim.
9.
I think
My Lord, his statement, my Lord, not in the case diary, my Lord. Maybe
he has appeared.
May I, my Lord, his statement is not
but
here.
he has appeared, right?
According to his statement.
All right, you have it tomorrow?
My Lord, day after tomorrow.
Day after tomorrow. Mr. So-and-so APP, Learned APP for the state respondent submits that though case diary has been received, however, the statement of the accused recorded under section 161 CRPC is not available in the said case diary. Stop. Accordingly, he seeks accommodation in the matter to place the same. Stop. Prayer allowed. List this matter on day after tomorrow.
interim order will go.
Interim order passed earlier shall continue till the next date of listing. Case diary?
Case diary received, my Lord.
Yes. You were not on interim.
FIR page 30.
You were not on interim.
No,
FIR page 30.
13.
1-3.
Page 17. Actually, Prisha is not involved at all.
Who are you?
I am Tapas Chaudhary.
You are not named in the FIR.
Yes.
Are you named? Not named.
No. Internally, my name has mentioned, but not claim against the petitioner.
You are Sri Tapas Chaudhary.
Chaudhary.
You are mentioned as a land mafia.
Yes, as per allegation, but not involved. One main accused, Sandoy Das.
Yes, what is there?
My lord, one thing, my lord, his bail petition is, my lord, recently rejected in my lord session court, my lord. So, my lord, updated version is not here, my lord. So, my lord, if lordship allows
When?
My lord, day after tomorrow, my lord. Rejection ground is, my lord.
All right, but let
it come, my lord.
It is submitted by Mr. So-and-so, learned APP, for the state respondent that that recently the bail application of the accused petitioner has been rejected by
Session judge.
the session judge, by the additional session judge, district, Kamrup. Stop. He accordingly seeks listing this matter day after tomorrow for producing the said order. Stop. Prayer allowed. List so-and-so. Nobody is present. None appears when the matter has been called. Stop. Actually, don't write this order right now. It accommodates option. It part hard as well. Jadi na hai, it release kori. This is that quashing matter.
Yes, ma'am. The case was called for, madam.
Case diary has come.
14 to.
No, my lord, case diary has not come, my lord.
All right. Mr. So-and-so, learned APP, for the state respondent submits that the case diary called for has not yet been received. Stop. List this matter after.
Day after tomorrow, my lord.
When can you have it?
My lord, from Guwahati itself, my lord.
Thursday?
Friday, my lord.
What's up? All right. List
Thursday, madam.
Thursday.
My
List
lord.
again on Thursday. Yes, Ms. Barmon.
Pursuant to earlier order, my lord, on set of instruction I have received.
1 second. None appears for the petitioner when the matter is called. Stop. List this matter on Thursday date with the remark for dismissal. None appears. After that you say MS M. Borman is present for the state respondent. All right. Yes. What is to be done in this matter?
My lord, this is a petition that has been filed seeking a fresh investigation or investigation in this matter. This matter pertains way back to the year 2006, my lord, when an FIR was filed.
You are alleging the inaction of the investigating authorities.
Yes, ma'am.
Yes.
So, my lord,
matter can be taken up for hearing?
Yes, ma'am.
All right.
My lord, one pair, my lord. Mr. K. Gogoi, my lord, Mr.
Huh?
Mr. K. Gogoi, my lord, he will, my lord, argue this case, my lord.
Where is he?
He's in Lex in another court, my lord. Let him stand, my lord, in case, my lord.
Let him come, then this piecemeal manner will become difficult. If he is coming, we shall keep it.
No, some other day, my lord, because he has
Yes.
some hearing matters
We
there.
met on the last occasion, so there was some time. 2006,
Only
my
for today, my lord, because otherwise, my lord, investigation was done, my lord. 3 times, my lord, final report was submitted. And for the 3rd time, my lord.
Then you are aware of the matter.
I simply aware, my
Why
lord.
are
Because
you seeking time? You are competent. Why should we wait for Mr.
No,
Kigogoi? All right, start.
because
If he comes, he'll come. You are competent.
Yes, my lord. No.
Yes.
Otherwise, my lord, he has prepared, my lord, that is why, my lord, with judgment, my lord. That judgment is not with me, my lord, that is why, my lord.
When do you want it?
Tomorrow.
As prayed for, list this matter tomorrow.
God bless you.
Kali to Milan. Any representation for the petitioner? None appears for the petitioner when the matter is called. List this matter day after tomorrow with the remark within quotes for dismissal. You are appearing? Yes. Kindly speak loud.
We have to take some instruction. For the last order, you know, in the order class could not consider our representation. The order dated, you know, 13 to 2018.
That's a 2018 matter.
Yes, probably.
Your name?
T. Gogoi.
Mr. T. Gogoi, learned counsel for the petitioner, submits that, no, don't say submits, seeks some accommodation in the matter in order to take up-to-date instruction from his client. Stop. Prayer is not opposed. List this matter.
Next week, Lordship.
Next week, after 1 week, next week, nalage tar paছত.
26.
May I please look?
Change point,
Impugned order dated 29/3/2019, passed by the Assam Board of Revenue under challenge. Impugned order dated 23/9/2019, passed by the Assam Board of Revenue,
Yes.
is under challenge. My name has been mutated as the occupancy tenant lordship by an order of
Who is appearing for the respondent in this matter?
SK Ghosh lordship.
Revenue Department.
It is a matter of
You are appearing, Mr. Hendik, in this matter? Right, then let's take up it for hearing. Yes.
My name has been recorded as the occupancy tenant lordship and order dated 30/10/2014 lordship by the Assistant Settlement Officer.
Just 1 second. Where is the impugned order?
Impugned order is page 11 lordship.
11A.
11A, Lord.
Yes, please.
May I read it, Lord?
Yes, please.
This is an appeal under section 147, review section 151, Assam Land and Revenue Regulation 1880 against the order dated 24/8/2016 passed by the settlement officer SO Gujri in Miss Appeal number 1 of 2015, dismissing the appeal of the appellant side, upholding the order dated 30/10/2014 of the ASO Golokund Revenue Circle passed in mediation case number 122 of 840. The appellant case in brief that late Helmesu Roy, predecessor in interest of the appellant, being the son of Helmesu, brother, was the Khatyandar, Rayat of the land in question. And after his death, the appellants being his legal heir were recorded as Rayat of the land in question. The respondent filed mediation case number so-and-so before the ASO Golokund praying for mediation in respect of the land in question as Rayat, implementing the name of some dead persons, and the ASO Golokund by his order dated 30/10/2014 illegally mutilated the partners and the present appellants who were the recorded tenant of the said land, being the highly aggrieved, the appellants filed this case number so-and-so before the ASO Dubai against the said order dated 30/10/2014, contending inter alia that the said order of the mediation passed by the ASO Golokund as the said order has been passed against dead persons without serving notice properly to the necessary parties, but the SO Dhubri by his order dated 24/8/2015 availed the order dated 30/10/2014 of the ASO Golokund illegally without applying his mind, being highly aggrieved at the said order 24/8/2015 by SO Dhubri, the appellant has prepared this appeal contending that the impugn order passed by the SO Dhubri is illegal and without applying his mind and as such is liable to be set aside. Respondent submitted written objection against the memo of appeal contending that the appeal is not maintainable. Learned counsel of both the parties have been heard. Both the parties have submitted written arguments also, perused the relevant records and report as well as the memo of appeal with the rejoinder and written objection of the respondent. The written argument with the connected documents including citation of case law of Honorable High Court and Supreme Court. On perusal of the relevant record and report with the connected document, it is
So, if I have understood correctly, you are the legal heir
my
of
name
the...
has been recorded as a riot, occupancy riot. The private respondent, they claiming themselves to the legal heir of one Helmesu Roy. They said that my name should not be mutated as a occupancy riot.
Because here they are saying that you are a dead person.
No.
No, what does this mean?
Their contention is that I have filed a mutation case against some dead person.
Correct.
Yes.
That is their contention, right?
That is their contention.
But according to you, you are the
According
rightful
to me, I am
legal heir.
possessing the land since 20-25 years.
You are possessing.
Possessing under the original Pattadar's lawsuit.
All right. Go ahead.
Para 4. On perusal of the relevant records and report with the connected documents, it is seen that ASO Golokund has passed its order dated 30/10/2014, allowing litigation in favor of the respondent Joson Ali, that is the as tenant of the land question, stating that Joson Ali has been possessing the land since last 20-25 years. But relevant record reveals that the respondent Joson Ali or his predecessor was not tenant of the land in question prior to granting tenancy on the other hand. Helmesu Roy, the predecessor in interest of the appellant, was the recorded tenant of the land in question, and after his death, the names of appellants were recorded as tenant of the said land as his legal heir. There is false lordship. Now here it is mentioned that their name has been recorded. Moreover, it is seen that prior to passing of the said order dated 30/10/2014, notice was stated to be served on the Pattadars, but they died before issuance of the said notice. There is also not proof lordship, whether they are alive or and their legal heirs were not substituted. On the other hand, notice was not properly served on the other necessary parties, including the present appellants, who were the recorded tenants as the legal heirs of Helmesu Roy. The original recorded riot is also pertinent to note here that a khatiyan, once issued, cannot be cancelled without following the proper procedure of law, as provided in the Assam Tenancy Act 1971. But the ASO Golokund allowed tenancy in favor of the Joson Ali, the respondent, mechanically without following the prescribed procedure of relevant law. Hence, the order dated 30/10/2014 passed by the ASO Golokund is not in accordance with the prescribed provision of law of the Assam Tenancy Act 1971, and as such, the said order cannot be allowed to sustain in the eye of law. On perusal of the relevant record of this case number so-and-so, case appeal number so-and-so, it reveals that the learned SO Dhubri passed his impugn order dated 24/8/2015 mechanically on the basis of ASO Golokund's order without causing any field verification, scrutiny of record, documents, and without following the prescribed provision of relevant laws of the Assam Land and Revenue Regulation, Assam Tenancy Act 1971, and without giving any opportunity to the present appellants for furnishing authentic documents to prove that they are the legal heirs of Helmesu Roy. The original recorded for tenant, but simply stating that the appellants claim that they are legal heirs and successors of Helmesu Roy cannot be considered until and unless the same is declared by the competent civil court. Since the SO Dhubri himself has observed that the question of legal heirs should be decided by competent civil court, so he ought to have either referred the matter to the competent civil court for decision, or should have asked the appellants to submit valid proof for substantiating their claim that they are legal heirs of Helmesu Roy, the recorded tenant. But the SO Dhubri availed the aforesaid clinical order 30/10/2014 of the ASO Golokund without doing the needful as per law. In view of the above position in hand, here of the considered...
Upheld means by which you were granted mutation?
Initially, my name has been mutated, Lordship.
Then it was cancelled.
They preferred an appeal to the settlement officer, and that has been dismissed. And against that order, they had preferred this appeal against the Assam Board of Revenue.
Yes. Yes.
In the result, the appeal succeeds and the appeal is allowed according to the impugn order dated 24/8/2015 passed by the SO Dhubri.
Which is this order 24/8/15 passed by the SO Dhubri?
Lordship, it is at page.
Just give the page.
Page 23, Lordship.
Page 23. What happened by this order?
Their appeal has been dismissed, Lordship.
Their appeal has been dismissed, against which they filed an appeal before the Board of Revenue. And the Board of Revenue allowed their appeal. That is why you are aggrieved. Correct? Okay.
My only question is that, Lordship, they claiming that they are the legal heir of Elmesu Roy. And unless and until...
There has to be some proof.
No proof, Lordship.
That is what? There is no evidence,
No evidence, Lordship.
that they are the legal heir.
Legal heir. And the learned Board of Revenue, Lordship, decided the title, Lordship. They have set aside the order and directed to record their names. It is beyond jurisdiction, Lordship. Revenue authority is not the competent authority, Lordship, to decide the title.
Yes, Mr. Hendik?
Judgment, Lordship.
Give.
Regarding this.
Yes, please give it. Yes. Which citation first you are relying?
Lordship, GLPC.
Yes. Yes. Paragraph?
Paragraph, I have only one copy, Lordship. So kindly.
Why? It's a matter when matters are fixed for hearing. Why don't you all come ready? You should be carrying copy for the court.
Sorry, Lordship. Para 9, Lordship.
Yes.
So, held that revenue court is not entitled to decide the title in respect of landed property, which is the subject matter of the civil court.
Yes, Mr. Hendik?
Lordship, should the heard the private respondent also, why this order has been passed in favor of them, Lordship?
Sorry?
The private respondent, their name, that council name has been shown in the list, They should be heard first, otherwise.
He is not present today?
Mr. Bhomik, Lordship, he is not present.
Bhomik was the earlier council, Lordship. Subsequently, they have changed the council, Lordship.
Who is it?
SK Ghosh, their name not shown in the list. That's why.
Why didn't you point this out? Unnecessarily judicial time has been wasted. This matter has been listed today with the remark within courts for dismissal, since on the last occasion there was no representation on behalf of the petitioner. Stop. Today, when the matter was called, petitioner was represented through its counsel, Mr. D. Kolita. Stop. Mr. J. Hendik, learned government advocate, is present for the state respondent. Stop. However, there is no representation on behalf of the private respondent number 3 and 4. Stop. It is submitted at the bar that there has been a change of counsel and the new engaged counsel, Mr. S.K. Ghosh's name is not reflected in the cause list. Stop. List this matter on
next week, Lordship.
Such and such date. Stop. Let registry to reflect the name of so and so in the cause list.
Day after tomorrow.
Day or day after tomorrow? 26.
20. God bless you.
Number 7.
Yes, could you contact the petitioner's
My
counsel?
lord, I tried to contact my lord. He has not received my call.
What is to be done?
My lord, kindly fix on my lord, another date, my lord. Another thing, my lord, lordship may dispose of it because my lord charge sheet is already filed. My lord. I have the charge sheet number.
A charge sheet file for order sample assessment. Charge sheet number.
Charge sheet number, my lord, 61/2024, dated my lord 304. 30
And here there was no interim.
My lord.
There was no interim.
My lord.
Before which court?
Before my lord, it is CGM Karimganj, my lord.
CGM Karimganj. Pariba na Abhishek? Kali last lot logai diba that in view of no representation on behalf of the petitioner, let registry intimate the order of this court by email / WhatsApp to both to the counsel as well as to the petitioner. Disposed of.
Item number 3.
Lordship, I am very much sorry, Lordship. I couldn't come in time, Lordship. Lordship, in this case, Lordship, I supposed to file affidavit, but Lordship, Forest Department and Revenue Department has given to
17 matter, Ms. Bora.
Lordship, Forest Department has given the stand that is their land, and Revenue is saying that is their land.
Sorry, so, Ms. Bora, go slow.
Lord, what Forest Department and Revenue Department claiming that lands are there. So
Forest is claiming the land is forest land.
And Revenue is saying that it's a revenue village.
Okay.
Then Lordship, let the Principal Secretary BTC call a meeting and decide matter within short period, Lordship. Otherwise, Lordship, it is...
you do what is to be done. Do you need any order to that effect?
Lordship, if your order is with me, Lordship, then it will go fast.
Yes, Ms. Sharma, you are appearing in this matter? You are not well? Ms. Bora is suggesting that this court direct the Principal Secretary BTC to inquire as regards the land. Can that be done? So we will not dispose of the petition, right?
Lordship.
We'll keep the petition. In the meantime, let that inquiry be made and a report be submitted.
Yes, Lordship.
Yes, you want to say something?
The land is a transferred subject. DC cannot.
DC cannot.
So, Principal Secretary is the
correct. Therefore, she
executive head of
let him do an inquiry as regards the ownership of the land.
Yes, Lordship. Executive head he is.
MS R.B. Bora, Land Standing Council BTC submits that as per the instructions received by her office, it appears that both the Forest Department as well as the Revenue Department is claiming over the subject land. Stop. In view of the aforesaid endorsement made by the Learned Council BTC, this court is of the opinion that an inquiry be directed to be conducted by the Principal Secretary BTC. Stop. Accordingly, let an inquiry be conducted by the Principal Secretary BTC within a period of and the exercise shall be completed within a period of
1 month.
1 month from the date of receipt of the certified copy of this order. Stop. List this matter after 1 month at the date on such and such date. And on the top, please record the appearances of all the parties.
Deeply.
But I am appearing on behalf of the petitioner.
Deeply.
That means item number 13.
13.
Abhishek.
13.
As regards the
I
ownership
made a short note on this, Lordship.
81. This is that part-heard matter.
Yes, Lordship. Lordship, earlier occasion asked us to submit a synopsis, Lordship.
This is about that herb collecting. Yes.
Hatgila tree.
So both sides have given their written synopsis. All right. In terms of the order dated 15/5/2024, parties have submitted their written synopsis in the matter. Stop. List this matter again on judgment dibole fix kora ase na 20 is a holiday. On 20 list this matter again on 26/2024 at 2 p.m. I'll try to give the order in the court. Nowadays it's very difficult to keep it CAV.
Deeply
You
obliged.
don't get any assistance inside, so it's better to everything.
May I take your lordship's
Yes.
indulgence in
Yes.
item number 15? I apologize, your lordship, that there was some delay.
What happened in 15? I have forgotten.
Okay, Lordship has directed as non-appearance for listing
dismissal?
in the dismissal column.
Oh, that matter. All right, we'll record your presence and we'll post it on that day.
Is it has been fixed on any particular
Yes,
date?
yes, it has been fixed.
On 13th.
Is it all right? Okay. Naam to Marshfile Whistler.
Lordship,
Yes, you want on another date.
13th, day after tomorrow.
Naam to Lulubo. Yes, Miss Ghosh.
I
That
apologize, Lordship.
maternity death matter.
Yes,
Yes, you were not there.
While reaching
What was your item number?
item number 4, Lordship,
Item number 4.
I seek
Just
apology.
record her presence. Monot to it. All right.
Deeply obliged, Lordship. Four.
Fresh notebook দিবচোন এখন পুৰণা বেলেগ এখন এখন ইয়াৰে Mr. Bhattacharya, which writ petition are you going to argue? 787 or 434? 434. Yes, please. এইটো বহুত দূৰত আছে ইফালে কৰিছো নাই সিং ঠিকে আছে এইটো Abhishek, you go now, we will call you. When you are called, you come. Yes.
Your Lordship, kindly come to page 62. And then,
Yes. Tender for supply?
yes.
Yes.
first clause says name of the work,
Yes.
the scope of the work. Third clause, estimated cost. 53 crores 93 lakhs 37.
Where is that mentioned, Mr. Bhattacharya? This is page 62 you are referring.
The first page of the notice, 61.
Yes, yes. Estimated cost.
Estimated cost.
Yes.
$53 crores, 93 lakhs, 97,000.
Yes.
Period of completion, 12 months.
Yes. Period of completion is 15 months.
15 months.
12 is for operation and maintenance. Yes.
Earnest money deposit,
Yes.
53 lakhs. 10 Miller. Your Lordship may kindly come to last day and time of submission of
Yes. 26/12/23 at 11 a.m. Yes.
then date and time of opening the technical bid.
26/12 11:30.
Date and time of opening the financial bid.
Yes.
After opening date. And validity of the offer
150 days
from the date of opening of
Opening.
the tender.
When was the tender opened in this case?
The pre-bid meeting took place on 22/11.
Pre-bid meeting.
Yes. 22/11/2023.
Yes.
Now, Your Lordship would kindly come that is more. Minimum eligibility criteria.
Yes. 2.0.
The interested bidders should meet the following minimum qualifying criteria: work experience, experience of having successfully completed similar works during the last 7 years, ending initial stipulated last date of submission of the tenders. 7 years will be complete only then. 3 similar work, each costing not less than 40% of the estimated cost put to tender, or 2 similar work, each costing not less than 50% of the estimated cost put together. C. 1 similar work costing not less than 80% of the estimated cost put to tender.
Yes.
Now, stopping short from here, now Your Lordship, we have objected to one thing, the preliminary, that is a proprietary firm. Proprietary firm becomes redundant only when the proprietor dies. It goes. Now, here in this matter, we don't know they have given tender in whose name, but it is an admitted position.
They mean R8?
R8. It is an admitted position in the mix. The order of the respondent number 8. It has. Now, we have taken that objection, Your Lordship will kindly.
So, because if I'm correct, you had filed a representation before the tendering authorities, and your case was that 2 of the tenderers, I think R7 and R8, did not meet the requisite eligibility qualification, right? And according to you, this representation was not considered. By ignoring the representation, they went ahead and ultimately they selected respondent number 8. Correct? Now, what is this specific eligibility condition which according to you have not been complied with? Which is the condition? Or we can straight go to the representation if you want.
Page 62.
Yes, I have page 62.
2.0 minimum
Yes,
eligibility.
yes, work experience.
C.
Yes, one similar work costing not less than 80%.
18% of the.
So this is not, according to you, respondent number 8 does not have this similar work.
Yes, that is one.
Clause
Page
2.01C R8. Yes.
And your lordship will kindly come to page 63.
Yes.
Clause A. Roman 3.
Yes, 3A.
3A.
Yes.
And Roman 3B.
Yes. What is this value of executed work? So the purpose of this shall also include the value of
Purpose of
materials.
this shall also include value of any material such as cement, steel, etc., services, scaffolding, batching plant, other machinery, etc., which have been supplied by the client employer free of cost on discounted price to the contractor and which have not been already included in the value of the works executed. That is reflected, declared on the relevant experience certificate or letter of award. Such exclusion shall be specifically mentioned on the letter of award. Experience certificate and the value of the supplies shall be separately certified by the employer, or in cases where the employer is a private entity, by a practicing cost consultant accountant holding valid certificate of practice. However, work executed as labor contract shall not be considered. C. The value of the executed work shall be brought to the current level by enhancing the actual value of work done at a simple rate of 7% per annum, calculated from the date of completion to previous day of initial last date of submission of the tender. Now these two to be read together.
And this is how the value of work has to be computed.
Yes.
Now, if you read A and B of subclause 3, then the tender, the similar work which they are relying is not satisfied. This is your second submission, correct? Now, how do you say so?
Lord?
How do you say so? You had set. There must be some basis for you to say that they do not have these eligibility conditions.
That will, your lordship will get NBCC's affidavit, Annexure 1, page 104. NBCC's affidavit.
Yes, I'm coming to it. 104.
Yes.
Yes. Paragraph 8.
Page 104.
Yes, which has paragraph 8, correct?
Yes. This is to certify that Messrs. Assam Supply Syndicate, having office at Satribadi Road, Krishnanagar, Guwahati, has executed and satisfactory commission 742 units at 48 urban local bodies of Assam.
Sorry, Mr. Bhattacharya, where are you reading from? I am at page 104, but which paragraph?
104 is the certificate.
Madam, it's the annexure which has been appended.
No, I have the affidavit, but the page is... This is the affidavit filed on behalf of R126, correct?
Yes.
Now, in this affidavit, which page are you relying?
124A.
Okay, okay.
Page number 104 with annexure 2, my lord.
No, there is some I think the pagination may not be matching then. Tell me the annexure number. Annexure number 2. Is it 24/8/21?
Yes.
Okay. Here in my copy it is 111. 104 has been struck. I don't know why it has been struck. Anyway, yes, you may read it.
This is to certify that Messrs. Assam Supply Syndicate having office at Chhatrabari Road, Krishnanagar, Guwahati, has executive and disciplinary commission 742 units at 48 urban local bodies of Assam against following or under this directorate within 31/3/21. Name of the work: design, supply, installation, commissioning of the IMAS limited lights which 6M pole with all fittings as per design and specification, civil and electrical works at urban local bodies of Assam. Order number so and so. Tender value is 39 crores 7,34,820. Date of commencement 2/8/2001. Date of completion 742 units completed as on 31/3/2020. Value of work completed. This is important.
Yes, I have
Value
noted.
of work completed rupees 38 crores 34,098,000. As per certificate received from the concerned urban local body.
Mr. Thakuria, you are appearing for NBCC.
Milord.
Now,
yes.
Benchmark, your lordship will get affidavit of the 126.
Yes.
Page 95.
Page 95. The same affidavit. Yes. Which paragraph? Because the pages may not tally. Yes.
Page number 94, just last portion
Yes.
of that paragraph.
Yes.
The lordship comes, they have fixed a benchmark for the work which was.
Can you read the opening words of that paragraph?
Paragraph 6.
Page 94, perusal of the above quoted clause.
One second.
Perusal of the above quoted clause 2.0
Yes, yes.
of the NIP and considering the total estimated cost put to tender is 53 crores.
So is this the benchmark?
53 crore is the estimated cost.
Is the estimated cost?
And your lordship will come see if lordship has
Yes,
said
one work of at least rupees 43.15 crore.
43.15 crore
Huh.
is the 80% of the total
Of
estimated
all
cost,
right.
which
Now
is the
here,
benchmark.
if we take page 111, that annexure 2, the value of work is less, 38 odd. Okay.
So what they have done,
Now, if your lordship kindly take clauses A and B together.
Yes. Just 1 second. Let me just note
That will be
this.
at page 363. G9.
Yes.
They have tried to.
No, which page?
Page 63.
63 is the petition.
Yes. Yes. 3AB.
As I pointed out to Lordship, here in page 63, Roman 3, clause A and clause B, they should be read together. But what happened, Milord, here? They have only taken B into consideration.
All right.
Overlooked
All right.
A.
Now they have done this according, but they have already worked out on a benchmark, correct? 48 something. This, according to you, that is correct. But while 43, and however, while taking the value of work, which is at that page annexure 2, while considering that, they have ignored 3A, and that is why they have come to a wrong. All right.
May I read one?
Yes, yes, please.
Roman 3A.
Yes,
the
please.
value of executed works for the purpose of this clause shall also include the value of any materials such as cement, steel, etc., services, scaffolding, batching plant, other machinery, etc., which have been supplied by the client, employer, free of cost, on discounted price to the contractor, and which have not been already included in the value of works executed. That is, reflected, declared on the relevant experience certificate or letter of award. Such exclusion shall be specifically mentioned on the letter of award. Experience certificate and the value of free supply shall be separately certified by the employer, or in cases where the employer is a private entity, by a practicing cost chartered accountant holding valid certificate of practice. However, work executed as labor contract shall not be considered. Now, your Lordship will compare that at page 104 of the NBC certificate.
The same annexure that is dated 24 August 2021.
That annexure 2? Yes. No, only thing is that how on a perusal of that.
The point is this, my lord, whether C, condition mentioned in the C, is
complied or not.
Implemented by these annexures here. Then only we can come to the...
Correct, because I was also thinking, now when you are reading 3A, how one will find whether this, what has been, it says the value of materials should also be included while considering the value of executed works, right? Now, if we see an Annexure 2 document, can one say that how this has been calculated?
We come again, my lord, to page 106.
Yes.
Certificate which has been endorsed by the competent authority.
That is at 106.
My lord,
what is the date?
Date is again 24th of August.
All right, this is the certificate by Director Municipal Administration. Yes, yes.
Here, my lord, they have not stated whether the price, discounted price they have worked or free of supply they have worked. If they have worked in free of supply discounted price, then
that is why there is an order of this court whereby the court has directed them to show if they qualify.
Yes.
Am I correct?
Yes.
May I read this?
Yes, please.
This is to certify that Messrs. Assam Supply Syndicate having office at Chhatrapati Road, Krishnanagar, Guwahati, Assam, has executed and satisfactorily commissioned 740 units out of 750 units against the work, design, supply, installation and commissioning of the high-S LED lighting system in 12 bit of some high work order number and so 27. The balance 14 numbers could not be completed due to non-visible site condition. Therefore, 442 units may be considered as final quantity and work is 100% complete. That means entire work could
not be completed
because of the inclement weather. This certificate does not show that they have, whether they have worked in a discounted amount or free supply of material.
It's not clear.
Nothing is mentioned about it.
Yes.
It only mentions about the number of units.
Yes. There must be materials on the basis of which the authorities can come to a conclusion that this is satisfied. 3 and 2 of that particular clause.
There be particularly the
value of work.
Material supplied free or work under discounted price. That is important. But they have only taken care of B, ignoring the A. In order to arrive at a logical conclusion, your Lordship will have to take A and B together.
Yes.
We have to read together this A and B.
Because the heading itself says similar works shall mean so and so. And then 2, 3. Work experience 1, then 2, 3. All right.
One about the Milord regarding experience. 3A. How we will come into the conclusion so far B is concerned? First read the A, 3A, and then come to the conclusion as far as B. CB. Am I clear?
Yes, yes. Both has to be
taken together.
But this is how you are interpreting. Let's see what NBCC, the author, says. Anyway, this is clear to me. According to you, A and B has to be taken together while considering the value of work. Correct?
Namely, Milord, that she say about the certificate considering these factors. It is mentioned there. And then you come to percentage, B.
Yes.
If it is missing from there, then we cannot calculate the amount on which there will be 7%.
Let us read 3AB once again.
Yes, sir. The value of executive works for the purpose of this clause shall also include the value of any materials such as cement, steel, etc.
Services.
Scaffolding, batching plant, other machinery, etc., which have been supplied by client, employer, free of cost on discounted price to the contractor, and which have not been already included in the value of the works executed. That is reflected, declared on the relevant experience certificate or letter of award. Such exclusion shall be specifically mentioned on the letter of award, experience of certificate, and the value of free supplies shall be separately certified.
So these certificates, something has to be enclosed, because where these inclusions, one I think is value of materials, number 2 is services,
yes,
on discounted price to the contractor, which if not included in the value of works executed as reflected in the experience certificate or letter of award. These are the key words, correct?
Yes.
So these has to be, if it is not there, then it has to be included.
Then you do not get the benefit of 7%.
That B, my lord.
as mentioned in B.
The value of sir shall be brought to the current
value of
level.
activity work shall be brought to the current level by enhancing the actual value of work done at a simple rate of 7% per annum, calculated from the date of completion to previous day of initial stipulated.
So this means
last date of submission of the tenders.
This current level is the benchmark they are referring here.
that 40 something.
43 lakhs. So in order to get the benefits of this provision, you will have to show that you have supplied something free of cost. You have done work on discounted price.
Then only
Then
7%
only you can take the
enhancement.
benefit of
7% enhancement.
Exactly, madam. But they have
If it is satisfied, then
These are the preconditions.
preconditions.
All right.
Then the point taken by us may not have any effect, but we are saying that it has not been.
All right. All right.
Now, Miller, regarding the respondent number 8.
You are a qualified bidder, otherwise. Financial bids have been opened. You've qualified your technical bid.
Now, your Lordship would kindly take affidavit by respondent number 8.
Yes.
Your Lordship got it?
Yes.
Your Lordship would kindly see Anurag Jalan, son of late
Ramatur Jalan.
Is it about 37 years? Then paragraph 1.
Yes.
That I am representing the number A in the instant case, and as such, I am fully acquainted with the facts and circumstances of the case. I am also competent and duly authorized to swear this affidavit in opposition, and accordingly I duly say, this authority letter is nowhere in the record that he was authorized to swear this affidavit.
Yes. But even if we don't go into this affidavit, ultimately the authority has to show that they had all the relevant materials on the basis of which they could do the evaluation and come to the selection. Correct? So it is for them to show that these materials were available or not available.
Whether this Anurag Jalan, whether he is competent enough to swear this affidavit and to contest this case.
Okay.
Because it is a proprietary point. And they say then we came to know Miller. Miller, this in reply, the affidavit filed by the petitioner.
Yes.
Page 147.
Yes.
Paragraph 4.
4. Yes.
That with regards to the contents of Your Lordship got it?
Yes, yes,
That with regards to the contents of paragraph 9(1) of the affidavit of opposition, in short, thereafter to be referred to as opposition, the humble deponent begs to state that the said affidavit in opposition has been deposed by one, Sri Anurag Jalan, son of late Ramatur Jalan, who contends to represent the respondent number Y, that is the Assam Supply Syndicate, and also claims to be duly authorized to swear and file the said affidavit in opposition. However, said person, deponent, in the affidavit in opposition have nowhere mentioned whether the private respondent A is a partnership firm or a proprietorship. Moreover, the said person has also not endorsed or annexed any authority letter authorizing the said person, Anurag Jalan, to file and swear the affidavit in opposition. The answering deponent herein therefore became skeptical about the veracity of the claims made by the said person and had made an attempt to find out the exact condition of the private respondent number 8 firm from the official website Goods and Services Tax. While doing a later research in the official website, it was found that said entity private respondent number 1 is a proprietorship concern. Now it is who found out that is it a proprietorship, which is admitted position now by them.
And the person had died. The proprietor has already expired.
Let me read this.
He is the father of the Anurag Jalan.
Yes. Let me read this.
Yes, please.
And their GSTN number is so-and-so, which said firm is further registered in the name of Sri Ramutar Jalan, that means father.
Yes.
GST is in the name of the Ramutar Jalan. It is further pertinent to mention herein that from the database of the official website, it transpired that even today, the private respondent number 8 proprietorship concern is registered in the name of the Ramutar Jalan. But surprisingly, the deponent in the affidavit of opposition clearly indicates in categorical terms that he is the son of Ramutar Jalan, meaning thereby Sri Ramutar Jalan is no longer alive. In fact, from the said official database, it further transpires that recently the said proprietorship concern, the private respondent number 8, had filed their GSTR1 return for the month of March 2024 on 11/4/2024 in the name of Ramutar Jalan. Hence, from the above material, it clearly transpires that the said private respondent number 8 firm is a proprietorship concern, and even today, the said proprietorship firm is registered in the name of the Ramutar Jalan. However, surprisingly, the person, the Anurag Jalan, who alleges to have been authorized to swear and file the affidavit in opposition on behalf of the person 8, clearly do not have any locus standi and legal authority to file, swear, and represent the private respondent number 1 in any legal capacity, as according to the said affidavit in opposition, the proprietor of the private respondent number A concerned is no longer alive. Therefore, in the light of the above, the contentions and averments made in the affidavit in opposition have no legal sanctity, validity, and are clearly unsustainable.
All right. All right.
Then, Miller, apart from above, it may further be mentioned herein that the answering deponent herein has serious apprehension that the tender submitted by the private respondent number A must have also been submitted by the same person, say Anurag Jalan. And if the said person has submitted the bid and on behalf of the private respondent number A, then clearly the said bid cannot be construed as a valid bid, as the same was submitted by unknown person having no authority under the law to represent the said proprietorship concern. Hence, the answering respondent, deponent herein humbly submits before this honorable court that the respondent NBCC authorities may be directed to produce the contemporaneous record pertaining to the tender in question, more particularly the bid submitted by the private respondent number A, in order to ascertain the above apprehensions of the writ petitioners. And if the apprehensions are found to be true, correct, then only...
Are the records available, Mr. Thakuria?
Not.
The records are available?
Original records are not available. Because
photocopies?
Photocopies.
You have it?
Because
the court might need to go see the records at some point. So kindly have them with you if they are not with you. Yes, Mr. Bhattacharya.
I will ask the local officers to
Yes,
be-
you kindly ensure that they are available.
My lord,
Huh?
I may be careful.
And
Yes.
this is the big document.
Yes. Annexure 1. Annexure 1.
Paragraph 5.
Right. But that bid document is that Annexure 1. 164. It says goods and service tax.
Annexure 1.
164, my lord. Yes.
That is the website from where you got this information, correct?
That is an annexure 1, page 164.
I've got it.
From GST, your lordship will
Yes,
find.
yes. You have already read the averments. This is the supporting document. Yes.
This is the support. It is in the name of
The proprietor.
Ram Motor Jala.
All right.
Then
Paragraph 5.
now, in response to this paragraph 4, the respondent 8 have replied.
In an additional affidavit, my lord. Kindly lordship take up the additional affidavit.
No, this affidavit is of yours. Against this, an additional affidavit in reply has been filed.
Filed by the respondent number 8, my lord.
Yes, I have got it.
172.
Yes, I have it.
That this additional affidavit is being filed to bring on record certain developments in the matter for proper adjudication of the issues involved in the present case.
Yes, please.
Paragraph 2. That it is humbly stated that the NIT was issued on 10/11/2023 and the last date fixed for submission of the bid was 26/12/2023. Accordingly, respondent number 1 submitted its bid 25/12/2003. That it is humbly stated that Sri Ramaraj, proprietor of the respondent number 8, was not keeping well. After submission of the bid, he executed a power of attorney in favor of the present opponent on 2/1/24, authorizing him to do or cause to be done or execute any act with the NBC in connection with the NIT dated 10/11/2023. Posing for a moment, now regarding the power of attorney matter, now they bring it up. Earlier they have not stated anywhere regarding that power of attorney. Till this affidavit is filed, my lord, we were under the impression that Anurag Jalan is the main man on behalf of the proprietor. And your Honor knows that once the proprietor dies, the proprietorship firm becomes dead.
Here, the proprietor expired on 17/1/24, right? Paragraph 4.
Yes.
After the submission of the bid.
So the technical bid was submitted. However, my lord,
Before-
before the contract was awarded to them, he passed away. Meaning thereby,
These dates, Mr. Buragwai, you might just give me a one-page note indicating all these dates.
I'll provide my lord.
Then, Miller, that thereafter Sri Ramanujam expired on 17/1/2024, and death certificate in this regard has been issued by the competent authority on 9/2/24.
Yes. And the next of kin certificate also is annexed at paragraph 5.
Yes, Miller.
Yes. Okay.
That pursuant to the above, the complainant
That's all right, Mr. Bhattacharya. I've seen it. Next of kin. Yes.
has been pleased to issue a next of kin certificate on 18/3/2001 in favor of the opponent, other family members of late Ramotar Jalan. That in view of the above, the opponent respectfully submits that he is competent and authorized to represent the respondent number 1 in the present proceeding. That this is that is the crux.
Yes.
Now they...
So your second ground of argument is that this Mr. Anurag Jalan, who
Rather,
has
that is my
submitted
first
the
argument.
bid on behalf of this proprietorship firm on the basis of an alleged power of attorney issued by his father. Ultimately, after his father has died, even that power of attorney will do no good because the entire proprietorship firm has become redundant. Correct?
In other words, my lord, on the strength of the power of attorney, this proprietorship firm cannot be revived. It is already dead.
That's what. All right.
And this, if they have the, my lord,
But this person died after the technical evaluation. After the evaluation.
According to this affidavit, he passed away
On
after
17th?
submitting. He said, after submitting the technical bill. So whether
Before evaluation.
it may be. But
That records will
yes,
show.
But evidently one thing is that my lord, when the contract was awarded,
He has
was
died.
not present.
He died.
He died. And the contract goes straight to the proprietorship firm. That cannot have been done. Could not have been done.
my lord, these annexer they have made, annexer C, and these are not disputed. This death certificate. Now, whether on the basis of that, these gentlemen can be represented a
That is one of the issue.
dead firm.
Only if this issue is answered in favor of them, then the second question will come whether they are eligible or not. Correct?
These things are admitted, my lord, that proprietor of the farm, response number A, is dead. And after he submitted the tender, if at all he has submitted.
Yes, these are all admitted facts.
Yes, admitted fact. But crucial point is in whose name the award was given but tender was submitted. Now, my lord, father may have submitted the tender, but thereafter he died.
So tender was submitted in the name of the proprietorship firm?
According to them, proprietorship firm. Who signed the papers, we don't know, my lord.
See, signing will not be...
Maybe.
It is the firm ultimately in whose name, and if there is an authority, ABC can sign. But if it is signed in the name of the proprietorship firm and after the proprietor died, because the tender has been allotted after the death, admittedly,
Yes.
whether that could have been done or not, that is the issue which is falling for consideration. Am I right?
Yes, sir. Because the impugned order
So
is-
in that, anything for to show about the legal effect of...
Yes, yes.
Yes.
my lord, the BCC, the general terms and conditions of
Mr.
contract-
Burakhwai, why are you so excited? Let your senior do.
Lord, this NBCC Limited.
Is a citation or guideline?
No, not citation. You just, I'm reading it, then I'll.
Yes, yes.
Termination of contract on the date of contract. Without clause 15.
On the death of?
Contractor.
Yes, please.
Without prejudice to any of the right or remedies under this contract, if the contractor dies, the engineer in charge shall have the option of terminating the contract without compensation to the contractor. It can be accepted. 15-0. Hand it over to you.
This is part of NBCC general conditions. GCC. $15.0.
15 point.
You just give me a photocopy of the front and the relevant, not the entire, because I don't think.
We have the copy of
Ash. If the contractor dies Option of terminating the contract. Yes.
So nothing on record.
Yes. Yes.
Paragraph 20, 2 would be relevant and 36.
You please mention the citation for their benefit.
2024 SCC online SC 212.
Paragraph
22.
236.
22 to 36. Okay.
So you will kindly take that
22.
paragraph 22.
Yes. Proprietorship firms.
Definition of proprietorship. In this regard, it is necessary to discuss the jurisprudential status of proprietary concern. In a report of the Insolvency Law Committee submitted on February 2020, the definition of proprietorship terms reads as under. Proprietorship firms are business that are owned, managed and controlled by one person. They are the most common form of business in India and are based in unlimited liability of the owner. Legally, a proprietorship is not separate legal entity and is merely the name under which the proprietor carries on business. So, due to this, proprietorships are usually not defined in the statutes. Though some statutes define proprietorship, such definition is limited to the context of the statute. For example, Section 2 HAA, the Chartered Accountants Act 1949, define a sole partnership as an individual who engages himself in practice of accountancy or engages in services. Notably, proprietorship firms have also not been statutorily defined in many other jurisdictions. According to Salmon, there are 5 important characteristics of the legal right. It is vested in a person who may be distinguished as the owner of the right, the subject of it, the person entitled, or the person of inherent. It avails against a person upon whom lies the correlative duty. That may be distinguished as the person bound, or as the subject of duty, or as the person of incident. It obliges the person bound to act commission in favor of the person entitled. This may be found as the content of the right. The act or omission relates to something in the widest sense of the word, which may be termed the subject or subject matter of the right. Every right was a title. That is to say, certain facts or events by reason of which the right has become vested in its owner. Salmon also believed that no right can exist without a corresponding duty. Every right or duty involves a bond of legal obligation by which two or more persons are bound together. Thus, there can be no duty unless there is someone to whom it is due. There can be no right unless there is someone from whom it is claimed. And there can be no wrong unless there is someone who is wrong. That is to say, someone whose right has been violated. This is also called as vinculum juris, which means a bond of the law. It is tied that legally binds one person to another. So and so. Salmon's classification, the proprietary and personal rights are these are given.
It distinguishes an inheritable right and an uninheritable right.
Yes.
Para 26. It says a right is inheritable if it survives the owner, and uninheritable if it dies with the owner.
Now, Your Lordship may kindly come to paragraph 36.
Yes.
But in the case of sole proprietorship, which is common form of business in India, when a legal obligation arises under a context which has to be discharged personally or by the sole proprietor,
Since deceased.
who is deceased had entered into the agreement, such as in the case of a development agreement, in the instant case, can such obligation be imposed on the legal representative or heirs who are not parties to the development agreement? And where the obligation under such an development agreement and where the obligation under such an agreement per se cannot be fulfilled inasmuch as they neither have the skills nor the expertise to do so, and those obligations depend purely on the skills and expertise of the deceased sole proprietor. In other words, proprietor, but based on the skills and expertise of the sole proprietor, we are of the view that in the latter case, the obligation which had to be performed by the sole proprietor would come to an end on his demise, and the same cannot be imposed on his legal heirs or representative. We reiterate that such a position is distinguished from a position where the estate of the deceased sole proprietor would be a partnership firm, is not a separate legal entity as compared to the proprietor, and his estate would become liable only to satisfy a decree or an order in monetary terms on this.
So in this case here, it was in context of a development agreement. Correct? Now, there I think because it's a development agreement, it has held that it will not be inheritable, because ultimately it is the experience of the sole proprietor which was taken into account. Now, if he has died, the same will not be inherited by the legal heir. This is what I think is the ratio of this decision, correct?
Yes.
Now, similar would be the situation in a contract, because the eligibility condition as regards past experience is that of the sole proprietor. Now, if the sole proprietor is not in existence anymore, those experience will go, isn't it? Because here the question of lifting bail will not come, which was expanded in the case of New Horizon. That I think is in the case of a JV, because at the end of the day, what has to be seen, whether these experiences are of whose. Now,
Experience
and skill, because that is important. Now here, going by the nature of the concern, proprietorship, it is normally the sole proprietor who is concerned. Now, if that be so, then perhaps.
Goes with the proprietorship firm goes with his date.
Perhaps.
It is directly on the point. So, to Delhi, Calcutta High Court. 2017 SCC, online Calcutta, 16988.
Yes.
Paragraph 2 में 2 and 3. Learned advocate appearing for the petitioner submits that the deceased mother of the lead petitioner has participated in a tender process floated by the rail authorities as a sole proprietor, so and so. The mother of the petitioner authorizes as a sole proprietor of so and so enterprise. The mother of the petitioner died on September 3, 2017. The petitioner has obtained a trade license in the name of S Enterprise on October 9, 2017. The petitioner is willing to proceed with the contract as entered into by the deceased mother as the sole proprietor of such so and so. And with that, the railway authorities on May 29, he refers to writing that so and so and submits that the reasons of cancellation of the tender is frivolous. These railway authorities are returned. Now paragraph 3. It appears that the Messrs. SNO was a sole proprietorship firm of the deceased mother of the petitioner. The mother and died on September 23, 2017. With her death, therefore, the sole proprietorship image of such person came to an end. General conditions of the contract 2014, particularly paragraph 9 annexure P1 thereof, which provides inter alia that if a tenderer expires after submission of the tender or after acceptance of thereof, the railway shall deem such tenderer as cancelled. Such clause has been invoked for the purpose of considering the tender obtained by Messrs. So and so.
Rupak. In the present case, the NBCC has that similar clause, the termination of contract on the death of the contractor. Correct? Anything else? Death of the proprietor.
These three on that proprietorship.
Paragraph. Just tell me the paragraph. No need to read. (18), 22, 23, and 24. Okay.
Let me point out. My learned friend has raised a preliminary point. Let me deal with that. Though it was on the border of the Mizoram.
Border of the?
Mizoram.
So, Miller, there is a high court. Now, according to them, we should not have come to this court, we should have gone to
Aizawl bench.
Now, Miller, first thing, that bench is also
part of this.
Design. But only thing, Miller, if we want to move there, in that case, we have to take a permission from the Honorable Chief Justice, which is we have not taken yet. But since it is under here, we have moved here. That apart, Miller, cause of action, partly cause of action has arisen here.
In that situation, one can always send this matter back to Aizawl bench. On that ground, definitely this matter cannot be dismissed.
So let them raise them.
It's all right, since now we are hearing the matter. I think if parties are consenting, this it can be taken up. Otherwise, it can always be sent to Aizawl bench. There is no difficulty.
My respected senior has given enough narration.
Yes.
and I have also enough. By the time my designated senior or my brother is also sitting.
But it is for you to now defend your actions. Two things that you need to meet. Number one, first argument is that on the death of the proprietor, that proprietorship firm has come to an end. Therefore, you could not have allotted the subject work to the proprietorship concerned, correct? Because of the death of the proprietor. This is number one. Number two, on what basis you have decided the value of work? Because the materials, according to them, is not available. For that, you probably will have to show from records that you had the materials.
Milord, absolutely correct. We want to go through the record because this Guwahati is not the proper place to file this suit because the tender was invited from Delhi, the settled at Delhi, allotted at Delhi, the work site at Mizoram. The Guwahati is nowhere connected with this.
No, but according to you, Mizoram has part cause of action.
Mizoram has a part cause, and plus GCC.
Because you see, then that is why I am saying here that cannot be a case of non-maintainable on the ground of jurisdiction because Aizawl bench is part of the Guwahati High Court. Generally, one should have taken a permission if this matter pertains to the Aizawl bench.
Exactly.
Now, if that permission is not taken and you raise this objection, then I shall transfer this matter back to Aizawl bench or I will ask the registry to place it before the Chief Justice to take an administrative call on the matter because that is the issue.
As per Clause 84.
Because on that ground, I cannot dismiss this petition. Now, if admittedly Guwahati, there is no cause of action whatsoever has arisen within the jurisdiction of the Guwahati High Court, then I think the proper course, if you are objecting, is to place it before the Chief Justice. Let the Chief Justice pass an order in the administrative whether the hearing will continue before the principal bench or it should be transferred to the Aizawl bench.
The GCC, Clause 83, the agreement shall be executed at Delhi.
That I have understood. You see, let's not go that far. Yes, Mr. Bhattacharjee.
Agreement will be signed at Guwahati.
No, that
part of the cause of action.
No,
absolutely correct.
Mr. Thakur, just 1 second. Has any part of cause of action arisen within the jurisdiction of the Guwahati High Court? From which document?
From the impugned order that has been challenged in the subsequent case, my lord, clearly indicates that a party upon whom the award will be bestowed will have to come to Guwahati Regional Office, sign the agreement.
So signing has been done here?
Yes, and plus performance bank guarantee.
Is been issued from here?
In Guwahati. Security deposit will be in Guwahati. The person who has responded will be in Guwahati.
Okay.
And the respondent themselves.
That is an admitted fact, Mr. Chaudhary. Mr. Chaudhary, is that an admitted fact?
No, my lord. No. In fact, in our affidavit in opposition, we have raised a preliminary objection. We have precisely said that no part of the cause of action has arisen within Guwahati. It is either in Delhi or in Aizawl. Therefore, ideally, they should have taken a
permission
on the administrative side from the Chief Justice. That is our case. No cause of action has arisen in the jurisdiction.
See, because otherwise there is no point of me investing more judicial time in this matter, correct? Now, if that be so, I can send it through a registrar. But but the other side is saying part of cause of action has arisen. Which document?
That is a communicating office.
I can come to page
Kindly.
second petition.
Why not in this petition?
Because the impugned order, we were apprehending that they will give it to them, and our apprehension became correct, my lord.
My lord, I can show from the tender.
1 second, Mr. Buragohai, 1 second.
Yes, NIT issued from New Delhi. Hard copy of the bid to be submitted at New Delhi. Pre-bid meeting held at New Delhi. As per clause 6 of section 2 of ITP also envisages that documents are to be submitted at New Delhi.
All right. Yes, Mr. Buragohai?
Kindly lordship may take up WPC 77.
Yes.
At page 70 is the impugned order.
Page?
70.
70?
Yes.
Yes.
Annexure 5, this is the order dated 30/01/2024.
Annexure 5, letter of award.
Yes.
Yes.
So,
Guwahati.
Yes, my lord.
Who is this Assam Supply Syndicate?
The private respondent number 8.
R8.
R8. And now, Lordship, may kindly come to page 71 of that order. I'll just read one paragraph.
Yes, yes.
Contract agreement. You shall enter into a formal agreement with the NBCC on non-judicial stamp paper within 30 days from the date of issue of this letter of award. Performance, bank guarantee and 5 numbers of non-judicial stamp papers of rupees 100 each are required to be submitted by you, Lordship may see, to the office of CGM. This is in Guwahati office. CGM SPG head for entering into a formal
How do you say
agreement.
this is Guwahati?
Yes, I'll come, my lord, because subsequent paragraph will show that this is the Guwahati office.
Yes, yes. This NBCC India Limited SBG.
Yes, my lord.
Huh?
Yes, my lord.
NBCC House, House
Yes.
Fed.
The House Fed, Guwahati
Dispur.
7006, Assam, my lord.
For this work at the following address.
My lord, for entering into agreement with NBCC India, it may be noted that no payment shall be made for any work carried out by you till agreement is executed, and till such time the performance bank guarantee has been submitted
But
by you.
Mr. Buragohai, you see, now if this point is also raised, this court has to ultimately give a finding on the jurisdiction, correct? Now, let me understand correctly what are the challenge. First, your selection is the selection of R7 and R8, correct? That is your first because according to you, they do not qualify. That pertains to only selection, right? Now, in that writ petition, possibly no cause of action has arisen within the jurisdiction of the Guwahati High Court, because till then award has not been issued. Subsequently, when the award was issued, it was issued to R8 at Guwahati. Here, probably, now if you are challenging this very award, then perhaps there is a cause of action.
And we, my lord, in the earlier petition, has also made a categorical statement that the local office at Guwahati is the supervising office taking care and control of all the NIT that has been...
That is in which paragraph?
Yes, my lord. In our petition.
WPC 787?
No, my lord, the original one. 434.
You have all the time. This is the only matter I fixed at 2. You can... there is no hurry.
No hurry. Lord, my junior friend has drawn the notice of the LOA, the clause contract agreement. May I disturb you for a moment?
I'll come to you because it appears this is one issue I'll have to now dwell into. So
yes. In that contract agreement...
Just 1 second, Mr. Thakur. Let him finish.
Yes, madam, may I read, madam? Paragraph number 2, page number 9 of my petition.
Paragraph?
Number 2, my lord.
Yes.
The respondent number 1 in the instant petition is the Government of India undertaking enterprise having its registered office at New Delhi, my lord, and also having its local office in Guwahati and Aizawl. In the address mentioned herein above in the post title and being represented by chairman cum managing director. Respondent number 2 to 6 are the authorities and functionaries under one corporation and under whose aegis the NIP dated so and so was floated and the tender process has been initiated. Respondent number 7 and 8 are the private respondents who also participated in the safe tender process and whose technical bids have been accepted and price bids have been opened by the tendering authorities despite of the fact that they are technically unqualified and ineligible bidders as per terms of the tender document. The state respondents are arraigned as party respondents by the legislative party in his part petition as being highly dissatisfied, aggrieved by the impugn inactions.
Come to the last paragraph. The respondent number 4 to 6 are the local authorities.
Under the respondent number 1 having its local office and at Aizawl in the address mentioned in the post title and under whose supervision authority the project in question, that is so and so under NIT, is being supervised and monitored.
All right.
Basically,
all right.
wash their hands away.
Very good. Yes, Mr. Thakuria. Which writ petition? 787 or 437?
437. LOA. Last para.
Writ petition?
Writ petition 787.
787?
Yes. The LOA.
Yes.
LOA. Last
paragraph?
Last para.
Page 70, Annexure 5.
Yes.
Yes.
Lordship got it?
Yes, I've got it.
The contract agreement.
Yes.
You shall enter into a formal agreement with NBCC on non-judicial stamp paper within a period of 30 days from the date of issue of the letter of award, performance guarantee, and 5 numbers non-judicial stamp papers each required, which were done at Delhi. And you submit it for entering into a formal agreement NBCC Limited. It may be noted that no payment shall be made at any work carried out by you till the agreement is executed, and till such time performance of guarantee submitted by agreement OM shall be executed separately at these all executed at Delhi. Only you submit it at Guwahati. That doesn't attract the jurisdiction of the Guwahati or this court.
No, but this LOA is issued to the R date addressed in Guwahati.
Yes.
Page 70. That Majitia's case, Mr. Chaudhary, that Shillong FIR, Bombay, Majitia and Majitia.
But my lord, in that ONGC case, because some communication was made in Calcutta, Supreme Court said Calcutta court will have no jurisdiction.
That is
that famous case of ONGC regarding federal jurisdiction under 226.
Just merely receiving a communication will not.
There I think it was in Gujarat.
Something more has to be shown.
Yes.
Mere communication is not enough.
Not communication is not enough. That is
Receiving communication.
Yes.
Because it has originated from
somewhere else.
From where?
Somewhere else. It is settled law.
See now, let me be clear, because if I have to first go into the jurisdiction issue, then no point in going much into the merit, because first I have to decide on the jurisdiction. And if I find that Guwahati does not have jurisdiction, nonetheless Aizawl bench will have. In that situation, I'll have to place this matter direct.
Utpal Kumar Basu.
Utpal Kumar Basu. Then I shall direct the registry to look into it. So you will have to take that risk, because you are saying your main argument on jurisdiction is that the order is issued to the R8 who is at Guwahati. See, that is in relation to his contract, right? In connection with his contract, he is signing papers here.
The contract will be signed in Guwahati.
Yes, but you see, Mr. Burago, what have you? The factum of challenge is to the selection. That entire process has been conducted not within the jurisdiction of this court, but that has been done somewhere between Aizawl bench and Delhi, isn't it? There is no doubt about that part of the facts, Mr. Bhattacharjee. That is an admitted fact, the factum of selection, because that is under challenge, isn't it? Now this is between including the award which was originated from Delhi, from NBBC office. From there they have posted and they have received it here. Now merely because of that, would they have jurisdiction? Because if you say so, then this court will first have to take up the jurisdiction issue.
Yes.
Right? And otherwise, no point of going into the merit right now. Because according to me, even for assuming that this court does not have jurisdiction, that does not mean this court will dismiss the petition. Because admittedly, Aizawl bench has. And Aizawl bench is part of the Guwahati High Court, isn't it? So in that situation, I will have to direct the registry to place the matter before the Chief Justice, who shall take a call whether the hearing shall continue in the principal bench or it will be transferred to the Aizawl bench for further hearing. This is one other course which I can adopt.
Provided your lordship holds.
I do not have jurisdiction. Alright, then first I will look into the preliminary issue, whether this court has jurisdiction or not.
Yes.
And if I find that this court has jurisdiction, then I shall travel into the main point which you've already argued.
We have already pointed out to your lordship part of cause action as rising.
By only indicating this page 70 document. This is the only thing which you have argued, yes, as far as the jurisdiction is concerned. Besides page 70, nothing else.
Bank guarantee.
No, bank guarantee is after page 70.
This bank guarantee and performance bank guarantee, everything will be deposited in the local office in Guwahati, which clearly states in this.
Correct. After the issuance of the LOA, correct?
Of course not.
So that is what I am saying. These are post-selection.
Correct. That is true.
The factum of challenge is the selection itself.
No,
Sorry, yes.
the selection is the part of the deciding whom to award. So that part is preceded. Once they have decided on that, then the next stage comes.
The consequent action.
And award is the main thing. Only by being fit or experience or that we are eligible. That will not do. It concludes with the award of the contract. That is the whole thing, and these are together. Things taken, your lordship
All
will
right.
take the cause of
Are you carrying those decisions on jurisdiction?
Lord Utpal Kumar Basu is a case, the facts are like this. The work was to be done in Gujarat, tender was from New Delhi, writ petition was filed in Calcutta. Like here. Here, my Lord, the...
You have the citation?
Yes, yes. 94 4SCC 711. I was just reading.
711.
We have filed the GCC's copy for your kind perusal. The jurisdiction, exclusive jurisdiction 83, GCC.
This is the part of GCC.
GCC.
See, this exclusive jurisdiction, there are a lot of decisions. Ultimately, even because here the selection is under challenge. This is not an arbitrary proceedings, correct? Arbitration proceedings. So this is not whole, but of course.
Their Calcutta High Court's order was interfered with by the Supreme Court.
Anything else? Any more submissions from your part?
My Lord, my submission is very simple. Also, to kindly have the repetition for a moment.
Which one?
434.
434.
Yes, please come.
Please come to page 75. Page 61 is the NIT.
In the meantime, can any one of the assistant counsels get me the citation of N. Majitia, 2000, I think. 2000
And
SSC.
Majitia is a bail Srinagar.
Yes, please.
Please come to page 61, my Lord. NBCC India Limited, a Government of India enterprise, Central Procurement Group, NBCC Bhavan, second floor, Lodi Road, New Delhi. So this is the tendering authority. Now, my Lords will kindly come to page 62.
Page 62, yes.
Yes. Please come to the fourth column. Period during which hard copy in original of EMD, if submitted in form BG, letter of unconditional acceptance of tender condition, affidavit for etc., where it has to be submitted.
Submission
Before
New
and
Delhi.
up to so and so
New Delhi.
in the Central Procurement Group so and so, New Delhi.
Submission of tender
Everything.
hard copies is
Everything.
at the Delhi office.
And please come to the last column, pre-bid meeting and venue, New Delhi.
New Delhi.
Then my Lords will kindly come to page number 75. Clause 6. The documents are to be submitted in the office of NBCC before the last date and time of submission of tender mentioned in NIT. So this is New Delhi. So entire cause of action has arisen insofar as NIT is concerned regarding its issuance and acceptance is Delhi, and the place where it is to be performed is Aizawl.
The work.
Yes. So therefore, in my humble submission, cause of action in respect of this case arises partly in Delhi and partly in Aizawl bench of this Honorable Court.
Fairly.
Of course, at a principal seat also it can be moved provided there is
There's a
permission
permission.
from the Chief Justice. That is the stand we have taken in our affidavit. I'll just
Which paragraph?
Yes. Our affidavit starts at page 109.
109?
Yes. Para 2.
One second, I have not reached. Yes.
Para 2 at page 110. That at the very outset.
Pagination here is different.
Oh.
This is 116. But this is
Okay.
the AO of R8, isn't it?
Yes. Para 2. At the very outset, the respondent number 8 humbly begs to state raise a preliminary objection regarding maintainability of the writ petition before this Honorable High Court. In this regard, it is brought to the notice of this Honorable Court that NIT dated so-and-so in question has been issued by the employer NBCC from its so-and-so New Delhi. Further, said NIT mandates that hard copy of the relevant documents are to be submitted in said office at New Delhi. The venue for pre-bid meeting is also the said office of New Delhi. That apart, instruction to bidder under section 2 of the general conditions of contract at clause 6 also envisages that the documents are to be submitted in the office of NBCC. Therefore, in the humble understanding of the respondent number 8, no cause of action either in part or whole having arisen within the territorial limits of this Honorable Court, petitioner perhaps hard in preferring writ petition before this court at Guwahati. As such, on this count alone, the writ petition so-and-so. Then my lord, second para, further even assuming, while not admitting that this court has jurisdiction to enter in the writ petition under 226(2) of the Constitution of India, so-and-so, because the work in question pertains to the state of Mizoram, then in that event also writ petition ought to have been preferred before that.
Permission admittedly not taken, right?
A respondent is not aware whether required permission of Honorable Chief Justice on the administrative side was taken before moving the instant writ petition in the principal seat of the Honorable Court. In absence of such permission, writ petition has to be not rejected actually, my lord. It has to be.
Yes. Even under CPC also tells
it's something like Order 7 Rule 10, my lord, return of the claim to present it before the appropriate
which has jurisdiction. But first, this court will have to decide whether now it's all bundle
I think
of
best
facts.
way would be to refer the matter to the Honorable Chief Justice. If the Honorable Chief Justice says it will be hard
Mr. Chaudhary, I would have taken that course, but now that the petitioner insists that Guwahati has jurisdiction, so this court will have to give a finding
on the judicial side.
On the judicial
Well,
side,
there
decide that.
There I
issue.
am relying on that Utpal Kumar Basu's case, that 1990.
I am fixing this matter on Thursday at 2 o'clock.
Yes.
Most likely I shall dictate the order in the open court.
Okay.
Before that, in case any one of you want to give any decision on jurisdiction, you can submit it to the court martial before Thursday. Yes, Mr. Bhattacharjee.
On jurisdictional point.
Yes.
2010 Supreme Court cases.
Ms. Burak Bahai. Yes. 2000?
2021 one Supreme Court cases.
Yes.
10 Supreme Court, 7
2020 10 SSC 766.
Yes, page number. Below that ONGC case is also relied on.
All right. And you had relied on some Utpal
Kumar Basu versus ONGC.
What is that citation?
1994 4 SCC.
1994.
4 SCC.
Yes.
711.
And I would like to add one.
Yes.
Swastik Gas Private Limited.
Just give me the citation.
That is in 2013.
Yes.
3 SCC
Yes.
365.
365.
365. I'll give a copy of the printout. And so far as the 83 clause is concerned, this is the swastik.
I think I remember that, but that probably is in relation to arbitration.
No, that is in say. I'll give a copy.
This jurisdiction clause 83 is part of the GCC. GCC. But GCC will come in only after the contract is given, isn't it? GCC is not part of the selection. These are general conditions of. It's part of the NIT.
Part of it. GCC, SCCs are always
part of the contract.
Part of it. Our lordship is correct. It is so far as arbitration is concerned.
That swastik, isn't it? Yes. I remember that. All right.
Third one more.
Yes, please.
2014, 9 SCC.
2014.
9 SCC.
9 SSC.
329.
329.
Copy is given.
এটা বেলেগকে ধৰে এইকেইটা jurisdictionৰ এইখিনি বেলেগ কৰি দিয়ে লাগি থাকিব এইখিনি এটা বৰ্ডত না all right and
in case I find any other relevant judgment,
Majithia, I think
by tomorrow we'll give it on.
2006 SSC 114.
Majithia.
Yes.
2008, 2000, year 2000, SCC 323.
Volume 8. SSC.
323.
No, এইটো ভুল কৈছে no, Nobin Chandra Majithia is different, Roba.
Correct.
2007 SCC 640. 640.
Mr. Chaudhary, it is
2007 SCC.
Yes.
Nobin Chandra Majithia versus State of Maharashtra.
Correct.
2007 SCC 640.
Limitation point is there in this, Mr. Chaudhary. You have the book.
Yes,
Limitation is there because an FIR I think was filed in Bombay. Investigation was.
No. This is in the context of 226(2). And the one lordship is referring to, I think he is referring to that.
That
2008?
Year 2008. Volume 8, Supreme Court, 323, my lord. This is in relation to the FIR, my lord.
My lord, may I submit so far as judicial review is concerned, so far as contract is concerned, one case, important case.
No, let's not go into that now because we are. This court is first confining to the jurisdiction. Because if suppose I hold that this court has jurisdiction, maybe then I'll have to hear Mr. Chaudhary on the on the merit also, because you have not replied on the merit.
Yes, we are not.
Correct.
Yes.
Because petitioner has placed their arguments on merit. So let me go through. That is why I'm fixing it only on Thursday.
Here also, but that Meghalaya case is referred in the judgment.
All right, I will have a look at it. Hearing remains inconclusive. List again on Thursday. Date to deliver I so and so at 2 p.m. I'm fixing it at 2 p.m. The Belek to fix karna hai Thursday.
Can it be tomorrow, my lord?
Tomorrow?
Yes. Maybe at second half.
Friday.
Day after tomorrow, I have some.
All right, tomorrow. If file to lagibo, it will be by slip. Mr. Bhattacharya, in case you have any difficulty, because I'm going to either pass the order open court or I might have to hear them. Yes. And then you may give your reply on another date in case you have any difficulty tomorrow at 2.
So far as the records are concerned, I talked to them. It was all at Delhi. Not
No, but you see, if we go into merit, this court will need to look into the record. So I would advise that you can ask your officers in Delhi to make photocopies and keep them ready. Depending whatever happens tomorrow, you may.
I think they can scan it also.
Yes, they can always scan and send it. There is no difficulty nowadays. So let them keep it ready. Whenever
I will ask them to, but it needs 7 days then.
No, that's all right. You scan copies can come through email on the same day. All right, tomorrow.
Yes.
It will cut us people again, please. No problem.